The last few years have witnessed a series of landmark judicial affairs in which victims of sexual crime have prosecuted their offenders. By their action, they have shaken the so-called respectable industries in which sexual assault were protected by silence. No community has been spared, neither the church, nor the cinema, not the sport, not the world of business. Action against figures of well-established industry have triggered one of the decade's most extensive social movements, the Me Too movement. In both sides of the ocean, in Europe and in North America, in courtrooms of New York or Paris, victims have had access to proceedings that they were not supposed to have access to. Their participation allows them to express their voice. But it's just a trend or modification of justice that will be here to stay? To answer this question, we must consider the difference between two legal models, the adversarial model and the inquisitorial model. In this image, you can see two courtrooms. The first one represents the adversarial justice as practiced in Israel or the United States. The second one represents inquisitorial justice as practiced in France or in Spain or other continental countries. In the adversarial model, two parties, the accused and his lawyer, and the prosecutor representing the state, stand in front of the judge. You can notice here there are no victims. In the inquisitorial model, you can see in one side the accused and his lawyer, and the other side the prosecutor, and here the lawyer of the victim, what we call in French the partie civile. The victims are part of the process as the accused. Description, I show you now, is not accurate anymore. Today, the traditional trial tend to disappear. A diversity of those flourish in common law and continental jurisdiction in Europe and North America. We can't describe all of these doors, but it seems that they were created without a proper reflection on victim standing and participation, and they were driven mainly by efficiency, concern to reduce costs, and managing of the court dockets. The creation of these doors has kept the victims and the accused silent. It has turned it back to discourse and lay people narrative and has become a place reserved for professionals. But as my opening suggests, some judges have used tools to provide victims and offenders the possibility to be active during the process. The flexibility of these doors, the fact that they can be adapted to different needs, provide them this possibility. These doors allow a range of opportunities. An opportunity for strengthening the rehabilitative, restorative, and therapeutic aspect of the law. An opportunity to create a positive dynamic between offenders and victims. An opportunity to reintroduce humanity inside the court and to enrich the legal debate, allowing confession, forgiveness, and rehabilitation. Instead of remaining outsider, victim, defendant, and ordinary citizen should become active participants. It is important today that these new doors, invented in the name of efficiency and speed, be reinvented to integrate human being and narrative as active participants in the criminal justice process.